Here are 5 reasons to avoid recorded statements with insurance adjusters. If you've been injured in a car accident, it can be a terrible ordeal. You probably just want to put it all behind you and move forward. However, if the responsible party's insurance company calls to ask for a recorded statement from you, it might seem like a reasonable request. The agent will most likely say they're just trying to sort through the facts about the accident. However, since their end goal is to minimize their responsibility for your injuries and therefore the amount they pay out, giving a statement can be a slippery slope and one that is best avoided. The adjuster, who has been trained in taking such statements, will present the request in a friendly, casual manner, making you think it's no big deal. From your perspective, you might think that cooperating with them will help you get your claim processed faster. So, should you give a recorded statement? As experienced Richmond personal injury attorneys, we advise against doing so. There are so many different ways that a recorded statement could be used against you if your case ends up in court. You have no legal obligation to give a statement to an insurance company that isn't your own, and any adjuster who tells you that you must do so isn't telling the truth. Here are 5 reasons giving a recorded statement to an insurance adjuster is a bad idea. 1. Your recorded statement can and likely will be used against you. In that sense, it's similar to a police interrogation when anything you say can and will be used against you in a court of law. A recorded statement is rarely a benefit to an injured party. Any statement, recorded or not, may have a significant impact on your claim. We highly recommend that you consult an attorney before you consider providing a statement. Your lawyer will make you fully aware of your legal rights and point out factors that could affect a potential future lawsuit. 2. The extent of your injuries may not yet be fully apparent. When you're in an accident, the resulting adrenaline surge can delay the full appearance of symptoms or mask the severity of your injuries for several days. However, the insurance company wants to rush to settlement to avoid a lengthy process. They may even contact you within 24 hours of the accident to ask you to describe your injuries. It's best to focus on the property damage at this early stage. If the adjuster persists in asking whether you were injured, tell them it's too early to discuss your medical issues. 3. Insurance companies will compare your statements with other statements you've made. Shortly after an accident, you'll give a statement to the police, even though you may feel rattled. If you move forward with a lawsuit, you will give a deposition to opposing counsel about the accident and the events surrounding it. If you provided a recorded statement to the opposing insurance company, all 3 statements can be compared for inconsistencies. If you unintentionally told a different version of the story on 3 different occasions, it may be easier for the opposing insurance company to find small inconsistencies which could hurt your case. 4. Insurance adjusters can trick you into giving responses that negatively impact your case, and you may not even realize it's happening. The adjuster has likely conducted hundreds of interviews and knows exactly how to word certain questions to get a response that can help them deny responsibility for your injuries. For example, if they are pushy about a certain aspect of the accident by asking the same question repeatedly, you may get frustrated and respond maybe, or I guess so. Regardless, it's on the record, and that response can be used against you in court. 5. Your recording can be used in court. Even if you think you will sound logical and polite, something you say could come back to haunt you. In addition, you may be on painkillers for your injuries, which could cause you to slur your words or remember the accident in a different way. An inconsequential discrepancy can become the key to discrediting your entire testimony. The exception to this rule is when your own insurance company asks you to provide a recorded statement. You may feel obligated to do so. And while your own insurance company is arguably on your side, there are situations where your words could still be used against you if the insurance company's position opposes your best interests. Once a statement is recorded, it can't be changed. As a best practice, never give a recorded statement to any insurance company. If you've been injured in an accident through no fault of your own, consult with the experienced personal injury attorneys at Commonwealth Law Group. We can help you navigate the turbulent post-accident atmosphere to help you get the compensation you deserve. Call us today for your free, no-obligation consultation about the specific details of your case at 804-999-9999. Justice starts at CLG.